Hello everyone, I'm Professor Paul Carrier of the Western Michigan University Thomas M. Cooley Law School. What I would like to do now is to provide some information with regard to Class 1 of Contracts 2. Congratulations to most or all of you for having passed Contracts 1, and we move into our second phase, which is Contracts 2. Don't forget that in Contracts 1, our major topics were formation, and we decide whether or not there has been a formation. We skipped breach. We'll talk a little bit more about that this term in Contracts 2. But after formation, we covered damages. So if you had a right to damages, there's a formed contract, then a breach, then you get damages, and we covered damages in significant detail. Finally, in Class 13, we covered one defense. A defense comes along when there is a formed contract. There's damage, but there is some reason that prevents the enforceability of the damage for a breach. Frauds. There may have been a contract. It probably was formed. But in certain cases, as we discussed, the powers that be, the court system, legislatures now have decided that there's such likelihood of perjury, forgetfulness, that it was improper to enforce contracts unless they were in writing. And as you recall, we developed that little moniker, mylegs.com. And those are examples. Remember, the general rule is that oral contracts are enforceable, right? They are not. They have to be in writing. There's a defense if they fall into those categories that we covered in mylegs.com. All right? This time around, we cover several main areas. The first 2 weeks, we cover the concepts of integration and interpretation. They are related, but they have slightly different terminology, and they occur at different points in a contract. And if you understand those two separate points of the contractual relationship, you will never mistake when you should be talking about integration and when you should be talking about interpretation. As long as you, early on, you catch on to that distinction. After that, we go into conditions. There are certain kinds of conditions, express or implied or constructive, which is basically a form of implied. You have conditions precedent, conditions subsequent, and they all have, which we will discuss. Okay? What they do, however, is they end, the general result of a condition is that it prevents or it ends the obligation of one of the parties. Example, if you don't deliver the bike, I don't pay. There's a condition of delivery of the bike before my duty to pay arises, by the way. And so we'll see that. It's different from a representation and warranty, which is simply a promise. You promise to act in good faith. If you breach good faith, that doesn't necessarily stop my obligations, but it does allow me damages for breach of the promise. So one of them stops performance. It prevents someone's duties under a contract. The other one doesn't necessarily prevent duties. It may allow suspension. But what it really allows is the ability to collect damages to lower the price, but you can't stop performing. Okay, so different limitations and warranties on the one hand, which are compensable by damages, and conditions, which stop someone's performance on the other hand, is a very important one in contract law. And if you become transactional lawyers, that will be very, very important to get your minds around. Okay? After we cover conditions, we go into what might be the most complicated area of Contracts 2, and that is third-party beneficiary law. The idea behind that is where you have one party promising something to another, so there are mutual rights and obligations, but one of the rights, or one of the duties, is owed to a third party. And the question typically becomes, when can that third party sue for enforcement? Stated another way, when can the party who created the right in another party revoke it and take it back? I promise to pay you $100. You want me to give the $100 to your nephew. I'm about to give it to the nephew, but before I do that, you ask me to give it back to you, not the nephew. Do I have to give it to you, or should I give it to the nephew? And that becomes basically the primary factual scenario when we're dealing with third-party beneficiaries. Related are the assignment of rights and delegation of duties. If you have the right to $100, you can assign that right to somebody else, and typically that's not a problem under contract law. What if I ask you to paint my garage and you are an artiste at painting garages? You're busy. Can you delegate the painting to someone else? Another contractor could paint my garage. Well, you would delegate that duty, but that is harder to do. Where it's a personal service or something unique to you, you may not be able to delegate a duty. Assigning a right is typically somewhat simple. Delegating a duty is more complicated. It's possible, but you have to be more careful before you decide that someone can legally delegate a duty. After we cover that, the third-party beneficiaries, assignment of rights and delegation of duties, we go into the rest of the defenses. We cover the first one, the statute of frauds, where you use a defense to enforcement against you of a contract because it needed to be in writing, and it's not provable. It's not able to be properly established without the writing. That is it. You've got formation. You've got looming damages, but you have a defense. There are other defenses, and they include unilateral or mutual mistake, and those two are related, but they have different tests. One is harder to get than the other. We'll explain when we get there in about week 9. There is duress and economic duress. If I force you to sign a contract at gunpoint, right, or I hit you or break you or threaten physical damage, you can get out of it. You have a defense. Did you sign it? Yes. Was it formed? Yes. Can you get out of enforcement? Yes. For the last, I'd say, 60 years, if not 100 years, we've extended that in most places to allow economic duress. If I threaten to throw you into bankruptcy if you don't sign a new contract with me, you can get out of that obligation under the concept of economic duress. There's also some defenses around mental capacity, and that is your capacity or lack thereof, the lack being a defense to enforcement, or infancy. There are some exceptions, however, to that. Certain contracts that are entered into by infants can in fact be enforceable, and we will cover at least a few of the major ones so you understand the general rule that infancy, for example, allows a defense to contractual liability, but there are certain exceptions to that, and we will cover it. Unconscionability. At the common law, if the enforcement of a contract would be very, very against public policy, then a court could decide not to allow enforcement based on its unconscionability. A similar idea that is steeped in UCC rules, Article 2, is impossibility or commercial impracticability. And we'll talk about that. We also covered in sales, if you take sales at a later time, and it's under UCC Article 2-615. But anyway, the concept is commercial impracticability in Article 2, and its common law counterpart is something that's unconscionable. Let's talk about integration now, which is the focus of the first class. The idea of integration is this. Let's say that you sent me an email with some information about an agreement. Then you made a phone call. This is a phone call. And you talked about price and quantity and et cetera, et cetera. Then, about 4 days later, we signed this agreement. The question is this agreement the full and final expression of our deal? Or is it supplemented by the phone call and the prior writing? Yes or no? And the answer comes down to whether or not this final writing is integrated. If it's fully integrated, you're not allowed to have prior or contemporaneous evidence. That falls away. If it's partially integrated to these things, not integrated down here, then you could use these only down here to where it's not integrated. But you wouldn't be able to use it to those parts where it is integrated. And we call that the parole evidence rule. With the concept of integration, the idea is this. Where a contract is fully integrated, or at least to areas of a contract that are integrated, you are not allowed to use parole evidence. That's evidence, that's other information that is prior to or contemporaneous with the making of the actual contractual writing. You're not allowed to use those things to contradict what is said in that writing to those areas that are integrated. So again, the parole evidence rule is that evidence of prior or contemporaneous agreements, terms, etc., is not allowed to supplement the terms of an integrated agreement. That's the concept between parole evidence. And if you can, try to remember, you've got different emails, you've got different phone calls, you've got different phone messages, you've got brochures, and they're floating around, okay, before the contract is signed. And the question becomes, do they go together so that they work together, or is it just this and these have to fall away? That is the concept of integration. And ask yourself, who makes the decision on integration, whether or not a contract is integrated or partially integrated. And as you'll see, as you look through the cases, in various points, your cases make clear that a court decides it. It's not an evidentiary rule necessarily. The courts say that it is a substantive rule of law. Okay? But courts decide whether or not something is integrated. Did the parties intend integration or not? If not, then prior and contemporaneous evidences are allowed to supplement but not contradict the writing. Okay? And then what the parties intended could then become a fact finder's question, which is typically the jury, but in a bench trial it would be the judge acting as jury. But keep in mind, and see if you can get your minds around this. Judge decides as a first line issue, is it integrated or not, such that other prior or contemporaneous information can be used. Okay? And the answer to that, if it's yes, then the fact finder decides what the parties intended. If the answer is no, then those things fall out and everything has to be decided based on the writing alone. Okay? So if you can get your mind around what part the court has to do and what part the fact finder does, you will be very much ahead of the game because it's somewhat esoteric and it takes a while to get your minds around. Okay? There are two main theories for integration and interpretation, and we like to call them, basically, we name them after the professors that espouse them. The first one is the Willistonian approach. Williston was a legal formalist, and he would follow what we like to call the four corners rule. If it's not within this paper, it should stay out. Okay, that's his general rule. And that's more of an interpretation issue, which is next week, but it has its implications with regard to integration, and I'll try to point that out and clarify it during the first class period. Then there's Corbin, which is also the restatement second view, and that is, when a court is looking at the question of integration, it should look at everything. And when it looks at the compilation of everything, it decides, okay, looking at everything possible, was this intended to be the final expression of the parties? Or was it open enough so that this can also be supplemented by prior or contemporaneous statements? So Williston would look at the four corners. Is it integrated or not? If it is integrated, nothing else. If it's not, okay, bring in the other evidence, let the fact finders go. Corbin and restatement second approach is, let's look at everything to determine the intent. If the intent was full integration, nothing else prior or contemporaneous to comes in. If it wasn't intended to be fully integrated, then we can bring in other things that are not inconsistent. Okay? So you've got a Williston formalist, you've got a Corbin mélange. I like to call it a mélange, which is French for mix, right, to determine the issue of integration. And some of the issues or some of the things that are relevant to integration, the goal is to figure out the party's intent on whether or not the contract is a full and final, in other words, a fully integrated writing to which nothing else can be added, or whether it was more open so other things could be added. And one of the factors includes a merger clause, also known as an integration clause. Does a provision say this is the full and final expression of the parties and nothing else can be brought in? That is not necessarily dispositive, but it's very good evidence of integration. And so it would take a lot for a court to believe that contemporaneous or prior writings, discussions, brochures, or evidence could be brought in. Possible, but difficult. Without a merger clause, it's a little bit more simple. But the court's still going to look at the intent of the parties. If the thing looks like this is what we intended and nothing more, everything else is negotiation, this is the final expression, then the court's going to decide on integration and work within the document. If it's not integrated, the court will take the agreement and it'll take things that belong within and integrate it. And once you have the final expression of the parties, however it's reached, then we go to week 2, which is interpretation. If it's in here, what does it mean? If it's clear, we stop. If it's not clear, we go through an assessment. So remember, integration decides whether or not things go in or are kept out. Interpretation is, we know what's in. This is it now. What does this mean? What within the agreement does this mean? And that's for week number 2. the interpretation issue. Okay, we'll be talking about quite a bit more of this when we meet for week 1.